Actually, evictions, I'm so excited, and it was purposeful when we chose the training topics for 2021 last year. I actually specifically chose evictions for September for two reasons. September is my absolute favorite month. It's the start of spring and everything is pretty. It's also my birthday month. So I decided, since I always claim September as my month, I will train on my absolute favorite topic for the month of September 2021. So now you have me actually doing a training session for myself for my birthday, because I enjoy evictions so much that if there's one topic I would like to talk about in my month, it's in fact evictions. So let's see if I can get you as excited about evictions as I am. So what I've done is I've done my normal little slideshow, and one of the main things is I don't actually want to do today's training on the theory of evictions, because the point is an eviction is an extremely technical part of the law. I've made together with the when does the CPA apply flowchart, I have an eviction flowchart on SSLR's website as well. I don't think I'm overly popular always with other attorneys, because I am so open about what an eviction should look like, how long should it take, what is the process that you should follow, and I make these flowcharts available for absolutely anybody to see, not because I'm trying to do something funny. I'm really saddened that after all these years on evictions still has a very bad reputation, and there's this fear aspect that comes with evictions that I really desperately want to get away from the property industry. So I've been presenting the eviction seminar on behalf of the Law Society of South Africa now for slightly more than 10 years, which makes me, realize that I'm not 16 anymore, because if you've been training attorneys on a topic for more than 10 years, it means that you've been doing it for slightly longer than that. But the point being, every time I do the training for the attorneys of South Africa on evictions, the exact same fear that I'm seeing with estate agents, with landlords, I see with attorneys, and I actually hear it often on the WhatsApp groups I have for most of the national agencies. The questions that always comes with this amazing level of anxiety and fear is surrounding evictions. I actually got a voice note over the weekend from somebody that was referred to me by an estate agency, and he said that he was told that an eviction, if it's unopposed, well, we're obviously in September 2021, he might be in court with that eviction in March 2022. Now, an unopposed eviction from September 2021 to March 2022 is almost impossible. You're really going to have to do absolutely everything in your power to delay everything. It can't take that long, but that's the thing that's out there. What's currently out there still to this day, it's been more than a year that we've been doing evictions in the national state of disaster. I still get questions. I still get questions where people say, Silna, but I've heard that we can't do evictions in the state of disaster, in lockdown. No, we can. We couldn't in April 2020, but from the 1st of May 2020, guys, this is way more than a year ago, we've been doing evictions and we've been executing them. The problem that we had is the lockdown regulation specifically says that you need a court order ordering the execution of your eviction order during the national state of disaster. Now, that's not really rocket science. You just need to ask the court for that. And sadly, I still get clients coming to SSLR now that obtained eviction orders through other firms that didn't request a court in order to allow them to execute during the national state of disaster. And now we need to go back to court and vary that order so we are allowed to execute. it's not a horribly difficult thing to do, but it is, again, another, say, 4 to 6 weeks to do that variation on the court order to allow the sheriff to execute. But it can be done. So even if you currently sit with an eviction order that wasn't done perfectly correctly with the prayers to allow the sheriff to execute the eviction order during the state of disaster, even that can be fixed. So let's see if we can, demystify evictions a little bit this morning. So let's start at the beginning. What is an eviction? Because I realized I've been doing evictions for way too long. And when I say eviction, I mean a court order. And you guys have seen my conversations with my good friends, Bruno Samau and Greg Vermaak, 2 other eviction specialists on the Property Law Alliance. And the 3 of us, when we talk about eviction, we only mean eviction court order. And then I realized on this Facebook page that we have, the Property Law Alliance, the type of questions that I'm getting, I'm actually starting to realize that when we talk about eviction, we mean the eviction court order. When most people talk about evictions, it means somebody was in a property and we need to kick them out, and that is called an eviction. So let's just clarify eviction. Eviction isn't somebody vacating a premises. Eviction is a court order, and eviction can only be done in one way, and this is in terms of Section 26 of our Constitution. This section applies to all evictions, commercial, retail, residential, every single type of eviction needs to comply with Section 26 of the Constitution. Now, here is, you've heard me recite this part of the Constitution many times, and I always recite Section 26(3) of the Constitution. But let's start at the beginning. Let's look at what Section 26 says. Let's quickly pause and think back on Section 25 of the Constitution. Section 25 of the Constitution is the section of the Constitution that says if you are the owner of land, you cannot be deprived of that land unless it is legally expropriated in terms of our expropriation bill. Now, obviously, a million conversations, remember the days pre-COVID, everybody was talking about Section 25 and the amendment on Section 25 for expropriation without compensation. And then COVID hit and everybody forgot about that one. The truth is, we are very much in a situation where our rights as landowners are protected by Section 25 of the Constitution. Should there be any amendment on the Expropriation Act, we will definitely know about that well in advance. So please don't worry about any of those rumors that we've read in the Huisgenoot way back when, before lockdown. Position is still the same, but I've seen the draft bills, and to be quite honest, I can't see any cause for concern on the current drafts, but that's irrelevant to this conversation. Why I brought Section 25 up is Section 25 protects the right of the property owner. And because that's such a strong right, the constitutional writers had to just bring a bit of a balance between Section 25, the strong right of ownership, and the right of occupation in Section 25. In Section 26, I'm sorry, which says everybody has a right to adequate housing. Now let's pause quickly on that one. This right to adequate housing isn't from one citizen to another. We don't have an obligation on ourselves to provide adequate housing for anybody else in the country. That obligation, and this has been echoed in so many court cases, big cases, well-known cases, like Blue Moonlight Properties, like Modderklip, Grootboom, a bunch of very big cases. This obligation is a municipal obligation. So it's a government obligation, but on a much lower level, on a municipal level, there is an obligation to provide adequate housing. Then the state must take reasonable legislative measures and other measures within its available resources to achieve the progressive realization of this right. So what we're saying is, let's do free or low-cost housing RDP kind of housing. This is the type of thing that we're talking in section 26(2). But section 26(3) relates to us and to evictions. No one may be evicted from their home or have their home demolished without a court order, without an order of court made after consideration of all the relevant circumstances. Look at me, I can recite this one easily, but if I have to read it, I'm like, whoa, that's weird. No legislation may permit arbitrary evictions. Now, section 26(3) is the reason why we now have the Prevention of Illegal Evictions Act, because what the Act says is, the Constitution says a court has to consider the relevant circumstances. Now we needed an act legislation to bring about what these relevant circumstances are and what would be fair. What do we need to do a fair eviction? So basically, the Prevention of Illegal Evictions Act, PIE, is all from section 26(3) of the Constitution. Why this is so relevant is, if somebody says something like, it is my property, I can just lock the guy out that hasn't paid, or it is my property, I will move into that property. All of those things are illegal actions, not in terms of the Prevention of Illegal Evictions Act. This is in terms of the Constitution. Now, just to go back quickly to our legal system in South Africa, the Constitution is the highest law in our country. The Constitutional Court is the court that has to enforce the Constitution and has to oversee the constitutionality of all the spheres of government. So all three spheres of government has to comply with the Constitution. This is the most important law in our country, and this is the highest law in our country. And if you get to that realization and you do appreciate that the highest law in our country says you are not allowed to evict somebody unless you have a court order, I think the message is quite clear. There's only one way of doing an eviction, and that is by way of court order. But let's just pause quickly. Why is everybody leaving their properties at the end of the rental then okay? Because that's a voluntary handover. If you give somebody the keys to a property, they're residing there, they're renting the property from the landlord, the lease comes to an end and they do vacate the premises, they hand over the keys. Fantastic. That is a natural way that it should end. It's only in a case where a person does not want to leave, where the contract has been cancelled or terminated. So the right of occupation came to an end in whichever way, even in the context of an owner whose property has been foreclosed on by the bank and the property was sold in execution. That owner will have to be evicted in exactly the same way as we would evict a non-paying tenant after we've cancelled the lease agreement. And it's exactly the same way that we will do an eviction of 100 to 400 shacks on a vacant piece of land. It's the exact same process. And if you understand that, it makes the laws behind this easier to appreciate, because if you only see one eviction and your eviction is in Camps Bay on a rental of 65,000 Rand a month, now we need to go through this whole process of saying, oh, shame, tenant, are you going to be homeless and destitute? And we're all thinking, he just entered into a lease agreement for 65,000 Rand a month and he passed the vetting. The prospects of homelessness is pretty low here. It sounds like something silly, but remember, our law has to be fair and just and equal across the board for 60 million people. So that one owner in Camps Bay, fair enough, that sounds silly to protect him, but we're talking about the thousands of people that has to be evicted from shacks or from low-cost housing, who's actually going to be left homeless and destitute. And the court has to know this, because they need to be able to make an order that is in fact just and equitable. And we, as the attorneys on evictions, has to bring all this information to the court's attention to allow the court to make an order that is just and equitable. And this is exactly where the specialization comes in, to be able to show a court the true circumstances of the illegal occupant in the premises to allow the court to make an order that is just and equitable. All right, so I have a few questions that I usually get. What is an eviction notice? Every time I get this question, I smile politely, because usually the question isn't a question. The question is usually, Silna, I have done an eviction notice and the guy's not out. Can I go lock the door? No, you cannot. There isn't a thing like an eviction notice in our law. What we have is, we have a breach letter, a mora letter, a letter of demand, whatever you would like to call that, where you say, Mr. Tenant, you are in breach of your lease agreement. You need to fix it, otherwise I'm going to cancel. And that will leave you in illegal occupation, and it will mean that you will have to vacate the premises. Okay, that's the one thing. That's clearly not an eviction notice. Then we have a cancellation letter. The cancellation letter says, Mr. Tenant, you haven't remedied your breach. We are now cancelling the agreement. And if you do not vacate the premises immediately, we are going to commence eviction proceedings. That demand to vacate the premises immediately is a cancellation letter with a demand to vacate because of the right of occupation that came to an end now. That's still not an eviction notice. The other option is obviously our notice of motion, where we commence eviction proceedings, but that's still not an eviction notice. The only thing that I can sort of see as an eviction notice would be your court order, where the court says, your illegal occupant, it's been real, I have considered your circumstances, you have a month to vacate the premises. If you do not vacate the premises in that month that I gave you, the sheriff can come and evict you. And then we have a warrant of ejectment. And now if there's one thing that I would call an eviction notice, it's probably that. But none of this can be issued by you, me, or the landlord. I can do a cancellation letter, as can the estate agent or the landlord. But none of us are courts, and none of us have the right to do an eviction notice. So try to avoid a terminology like that. It sits right next to the same terminology as squatter rights. Now, every time I hear the word squatter rights, I roll my eyes so intensely I can see my medulla oblongata. And the truth of the matter is, there is no such thing in our law. I don't know where it comes from. I do believe the closest country that I can get to on something like squatter rights would be American law. But in our law, we don't have that. In our law, we have the Protection of Illegal Evictions Act, Prevention of Illegal Evictions Act, which says that you're not allowed to do an illegal eviction. But nobody receives rights ever. No illegal occupant will ever have a right of housing or will have a right to occupy the premises. The right of housing, as I showed you, is sitting in section 26(1) of the Constitution, and that housing right is a state duty. It's not a parallel sort of obligation that we might have towards each other. There's definitely no such right. So please remember this, there is no such thing as squatters' rights, and there is absolutely no such thing as an eviction notice. It's really important to be aware of this. The only time, and I don't want to confuse you with this, but I do want to mention it because there's always exclusions in law, the only place where an illegal occupant will obtain a right to a premises is in terms of ESTA. So ESTA is the Extension of Security of Tenure Act. And ESTA and PI, the Prevention of Illegal Evictions Act, is not even closely the same piece of legislation. They don't look the same, they don't create the same rights, it's very different. ESTA relates to people who had consent to reside on land. Consent means there is no counter performance, so it's not a rental. And it's only limited to certain parts of the country, only rural or peri-urban land that's not encircled by a township. Has nothing to do with the zoning. It's about the location of the land. And that person had to have consent to reside. So it's not a tenant on a farm. This is somebody, a farm worker that had a right to stay on a farm. Now the property was sold and somebody wants to evict this person. And the only person that will have a right to that land is somebody that had that consent, that resided on the land freely, openly, and with the owner's consent for more than 10 years. And that person is now older than 65. That is the only piece of legislation in South Africa that will give somebody other than the owner a permanent right to a piece of land. So please, guys, this is not your type of tenants that we're talking about. Even a tenant on a farm, this is never, ever, ever, ever the kind of evictions that you're going to be dealing with, because the evictions you are dealing with is in terms of PIE, the Prevention of Illegal Evictions Act, and it does not give an illegal occupant any protection other than allowing a court to consider the circumstances of that particular illegal occupant. Then, who's responsible to start the eviction? Always the landlord. You as the rental agent on behalf of the landlord, depending on your mandate, if you have a procurement mandate, a placement mandate, you're only going to place the tenant, and if anything funny happens along the line, that's a landlord problem. And next time, we must please remember to sign a management mandate. Under a management mandate, you will have the obligation to do a letter of demand and cancel the lease agreement. But at that point, your obligation as the landlord, as the agent on behalf of the landlord, stops. You do not have a mandate to act on behalf of a landlord in an eviction. The only time you will have that right, and I strongly discourage you from taking instructions like that, would be in a case where you have a power of attorney to act on behalf of your landlord. The reason why I'm saying I'll discourage that strongly is you're going to make decisions, legal decisions, on behalf of the landlord that I think, A, you won't receive proper remuneration for, A, and B, the risk of things going south for you, and then you are the one standing in front saying, I was the one that signed this affidavit, I was wrong, I didn't have the full knowledge. The court dismisses the application and it falls flat back into your lap. I would strongly discourage you from doing that. However, in certain circumstances where a landlord is, for instance, abroad in a country that doesn't form part of the Hague Convention, where we can't just go and commission that affidavit with a notary public or something like that, where you actually have to go to the consulate, for instance. There's a lot of countries. I'm not going to start doing that now, but there's a few countries like that. Then I might recommend that the agent take a power of attorney if there's really nobody else that does have the full facts. But if you do that, I promise I'll make sure that power of attorney protects you as well as the agent, so you don't have to take on risks that you shouldn't actually as an agent take on. So always landlord's responsibility. And when do we start an eviction? As soon as we've cancelled the lease agreement, we demand that the tenant vacates immediately. If the tenant doesn't vacate, we commence that eviction as soon as possible. And the tenant still has a long time before we're going to be in court. An eviction takes about usually in the old days 6 to 8 weeks. Currently it's more in the region of about 2 to 3 months if it's unopposed. If it becomes opposed, it could be longer, more in the region of 6 to 8 months. Most of our lease agreement type of evictions will remain unopposed. So 2 to 3 months, they still have time to vacate. So don't delay commencement of the eviction process because the tenant says he vacates. Cool, let's start the process. If he does vacate, fantastic, we stop the process right there. But if he doesn't vacate after the 2 months he promised and we only commence proceedings then, the landlord's going to be proper out of pocket. Will the tenant, who's now the illegal occupant, have to pay the legal fees of the eviction? Most of the times, in most court cases, the cost order will follow the party that was unsuccessful. That's a harsh way of saying it, but it will follow the unsuccessful party. And in an eviction, I can promise you, in 99.7% of the time, that unsuccessful party is the respondent, is the illegal occupant. The fact that we cancelled the lease agreement means the tenant didn't pay his rent in most cases. The chances of him paying the legal costs are few and far between. It's a further process to have your bill of cost taxed by court, and usually we appoint cost consultants to draft a bill of cost simply because lawyers shouldn't really hold calculators. My favorite conversations are always with the estate agents that are also accountants, and I can clearly hear they have a good giggle if I try to figure out a calculation. So we usually appoint cost consultants. They are the cost people. They know where debit and credit is on an account, and they usually have more success on taxation of bills, but it's a further expense whether you use a cost consultant or not. And then you have a warrant of execution, but like I said, the prospects of success on collecting on that is few and far between, and I would not easily recommend that, simply because we don't like to throw good money after bad. But you will get a cost order, but I'll never convince a client to instruct on an eviction based on, don't worry, the tenant is anyway going to pay for the legal cost. That's not a safe thing to do. Then, my favorite question, does the Rental Housing Tribunal have the right to grant eviction orders? No, they do not have the jurisdiction. They try to do it, and sometimes in mediation, the outcome might look like an eviction, but you can't issue a warrant of ejectment on the back of that. We can issue a warrant of execution in the magistrate's court on the back of, say, a rear rental or a deposit claim from the Rental Housing Tribunal, but the tribunal does not have the right jurisdiction to grant an eviction order, so you can't issue a warrant of ejectment on the back of a tribunal order. How long does it take for the owner to get his property back? Oh my goodness. Like I said, commencement of the eviction process is crucial. You have to start as quickly as possible. Residential evictions currently, like I said, you're going to look at about 2 to 3 months, depending on where the property is situated. If we are in a suburb where we can go to Randburg Match Court, for instance, Cape Town Magistrate Court. Actually, most of the Cape Town Magistrates courts are actually quite quick. Cape Town High Court, South Gauteng High Court, those evictions run amazingly quickly. If we are in courts, for instance, in Pretoria, both High Court and Match Court, if we are in Durban, my goodness, High Court or Match Court, those evictions are slower. And it's important to be aware that every court has a different process, and there's different reasons for the delays in different courts. But on an average, it's going to be about 2 to 3 months. But then the court has to say how long this illegal occupant has to vacate. And sometimes it's a month. Sometimes the court says, this person is disabled, or they will be left homeless and destitute. We need municipal intervention. Then the court might grant slower orders. The longest time period I have seen that we've received in SSLR from order to when the tenant has to vacate was 3 months, which is actually quite quick, but the longest I've seen was actually an eviction in PE, where the court allowed them 6 months to stay from the date of order until the sheriff can execute the eviction order. Most of the time, residential, you're going to look at about a month. So you can be prepared for a month, but it depends on the judge, it depends on the circumstances, and it depends on where we are. In the winter, I must say the judges are more prone to give slightly longer time periods to vacate. And then every time the tenant comes with a funny thing, I actually recently did an eviction. I don't usually do our appearances. The attorneys in SSLR does that. I do fund trainings and stuff. And I did an appearance for one of our attorneys in July, and I got the order for the tenant to vacate on the 31st of August. And on the 30th of August, they filed an application for leave to appeal. The good news is that's obviously out of time, and we were still allowed to execute that eviction order. So don't be thrown off by funny legal things. But once again, this is why you need to instruct a specialist eviction firm. if an eviction firm isn't really 100% ready for anything that can hit you, because I can promise you in an eviction, you see everything from guns being pulled on our messengers. I'm not even exaggerating. When we deliver cancellation letters, to people rocking up at court, threatening you, and pulling every single potential move to get away from this eviction. If you're not 100% comfortable with that, it could throw you off. And unfortunately, those are the evictions that take longer. When can you start looking for a new tenant? Please not when the court order is granted, because if the court says they need to be out in a month from now, and you as the agent start listing and you sign that lease agreement, what if they do not act in terms of the court order? We need to still issue the warrant of ejectment. We still need to get the sheriff out there. If the sheriff needs police assistance to attend to the actual eviction, it could be another 2 months from the date of court order. So wait and communicate throughout with the attorney during the eviction. They will know when you can start listing the premises again. Otherwise, you're going to sign a lease agreement and the landlord's going to be in for damages of the tenant that can't take occupation. What is the agent's responsibility? This is actually a very important question. The truth about the agent's responsibility in an eviction is many agents feel sort of guilty about an eviction. But the truth is you did absolutely nothing wrong, unless you did, but I'll get to that on my case study just now. You did nothing wrong. You did the vetting, you fulfilled your mandate, you've placed a tenant, something happened, and the tenant is now not paying his rent. Either he got retrenched and he can't pay, or he's just a silly, sort of career squatter. You didn't see that, you did the vetting properly, and there were some things that happened. You couldn't have foreseen this. At the point of cancellation, the agent has to step away from the eviction. Why? An eviction is a frustrating process, and I promise you, I don't think we've ever done one eviction where the client was constantly happy, because even if you do your absolute best and you get your eviction done in like 4 weeks, I promise you the client's going to complain, because now the fees were stacked too closely to each other, because we spread our evictions over 5 phases. So the client knows exactly what he's going to pay per phase. And if the tenant vacates during any one of the phases, we can obviously just stop our billing right there. So now if you do an eviction too quick, it's the cost is going to be crammed up much quicker. The client will be sad about that. Why? Evictions will be a grudge buy every single day of the week. Nobody wants to pay for an eviction. It's like a divorce. Unless you're really, really unhappy, you're not going to want to pay the legal fees for that. It's really not the best and happiest thing for clients to be in. We are used to that. You as the estate agent want that mandate again, and you want to place the tenant once we are done with the eviction. Let us handle the eviction. Let us take the client's frustrations. We know how to handle that. We know how to calm the client down again and talk him through it. We're more psychologists than eviction lawyers. But for you as the estate agent, we need you to be as far away as possible. We'll update you so you know what's going on. But it's not like the conveyancing process where you should be actively involved. You can help us by sending us the lease agreement, letter of demand and cancellation letter, but that's about it. Further than that, you should never, ever be involved. You should never be the one delivering letters to the tenant. You should never communicate with the tenant after that. You shouldn't be invoicing the tenant unless you are invoicing for holding over damages, because you can either accidentally reinstate the lease agreement or expose yourself to a massive risk. Like I said, we've had our messengers had guns pulled on them quite a few times. People really don't like being evicted. Don't know why. But it's a very high emotional thing. So I need the agent to be as far away as possible. Let us know what kind of feedback you would like to get, but we will take good care of the client, because it is our client and we are committed to providing absolute excellent service to the client. So we will do that feedback, and we need the agent as far away from the eviction as possible, so we can protect your relationship with the landlord as well. He'll forgive us when the sheriff gets the tenant out, but he might still be a little upset with you. So we need you to be away from the eviction process so you can have time to forgive you and you can maintain your mandate and place the tenant. So illegal evictions is actually a very big thing, and it's a problem. And this is everything from disconnecting utility supply to moving in with the tenant to getting those big guys with the baseball bats moving in, taking off the front door and saying that you are doing maintenance. Everybody is seeing straight through that. This is all acts of spoliation. So spoliation is where you are depriving somebody of possession, even if that possession was illegal. The problem is, already in the current Rental Housing Act, these actions are actually criminalized. Luckily, the police doesn't know really what to do with that, but I've had clients being arrested for deprivation of possession. And I've actually had scary stories. I've had clients that called us and they weren't happy with the costs on an eviction. And they got the guys in that moves in with somebody, and they always tell this story very lightheartedly and as a bit of a joke. Like the first morning, this big guy walks out of the bathroom and, you know, everybody would want to move. The problem is I've had clients where they decided to go against my advice and actually go for these big guys that move in with the people, and items got stolen. And my client ended up being a co-accused in that, and even scarier, I've had a client where there was assault involved, and unfortunately my client ended up being a co-accused because they allowed this access to the premises. Those things are scary, guys. You feel like you have to protect your owner, and the owner might instruct you to do this, but please stay away from that. It is very, very scary. This is the quickest way of actually ending up in jail potentially. And I promise you, your mandate doesn't require you to go that far. None of this, not reduction of water pressure. The only way of getting someone out is to do an eviction. But when will an agent be responsible to pay for an eviction? And I unfortunately have a story on this as well. I had a client. The lease agreement was signed. The tenant was supposed to take occupation on the Saturday. She was in a rush. Tenant was in a rush, and I'm always concerned about a tenant that wants to take occupation very quickly, because why is it now such an urgent thing? And I've heard amazing stories, but I'm always reluctant when it comes to a tenant that's now desperately wanting to get into a property. And what happened is he signed the lease agreement on the Thursday. She said on the Friday, please pay the deposit and the first month's rent. He said he was so busy packing, he couldn't, but he will bring the proof of payment with him on Saturday. Now, in this moment, I am sad that this is a webinar and I can't see your faces, because I can clearly feel at least 5 of you doing this. This is such a bad idea, but unfortunately, she did allow him access to the premises. He moved in on the Saturday, just on the proof of payment of the deposit and the first month's rent. Obviously, that was a fraudulent proof of payment. He took occupation, and she only realized by the Monday that money is not in her account. She pressured him for another week or so. By that time, she had to talk to the owner. She told the owner what happened, and we had to do the eviction. And unfortunately, because of the estate agent's gross negligence, allowing this tenant occupation without actually having that money in her account, she had to pay for the eviction. That was the saddest story I have had on an estate agent, because it was a very silly mistake from her. And I hope that this story would make you guys avoid falling into the same trap. But let me quickly go through the eviction process. So, like I said, this flow chart is in so many different forms. Also on our website, you have seen this part of the flow chart a million times, the top part to bring us to cancellation, but to quickly take you through the eviction process, just so you know exactly how it works. We have 3 documents. We have our notice of motion. This is similar to a summons, but this is in application process, not in action process. So your notice of motion has a founding affidavit. This affidavit has to be signed by the owner of the property or somebody with a power of attorney on his behalf. This can also be a tenant who was allowed to have a subtenant, and that tenant will also have locus standi to bring an eviction application. Most of our matters, the applicant is actually the owner of the property. We need to prove ownership in this document, and we need to prove illegal occupation. So this means those letters that you are doing, your letter of demand and your cancellation letter, this is the most important proof we have to prove illegal occupation. And you need to be aware of the fact that those letters that you are sending out, the email, the everything, this ends up in front of a judge and they read it word for word. So you need to make sure every letter that you draft that might end up in litigation, you draft with a judge in mind. They are definitely going to read it. Then we have another document. We have the ex parte application. So ex parte simply means one party. Your ex parte application is in terms of the Prevention of Illegal Evictions Act, simply an application coming to court saying, court, I am busy with an eviction. Here is my notice in terms of section 4.2 of the Prevention of Illegal Evictions Act, telling this person that he is being evicted, the reason why he's being evicted, and that he has a right to come to court and oppose this eviction. Will you, court, please tell me how I must serve this document and also authorize this document? Tell me that I've complied with the provisions of section 4.2 of the Prevention of Illegal Evictions Act, and allow me, please, to serve this. Tell me how you want me to instruct the sheriff to serve this document. And that will be either on a person older than 16 at the premises, in rare circumstances by attachment, but ideally on the respondents personally. If the matter is unopposed, we can immediately proceed to the ex parte and then get the 4.2 notice issued, sent to the sheriff, and 14 calendar days after that, we are allowed to be in court, but we obviously have to wait for the court to give us the court date, which is usually more than 14 days from there. If the matter is opposed, so the tenant says, you know what, I actually have a defense, even if it's a wishy-washy defense, we have the audi alteram partem rule, so both parties are allowed to bring their story to court. And in that case, we have to wait for the whole exchange of pleadings to end. So it will be in the form of an answering affidavit by the respondent, where the respondent now answers to our founding affidavit. We as the applicant then have a chance again in our replying affidavit to reply to the respondent's answering affidavit. After that, we have to draft our heads of argument, which is basically a document telling the court, these are the cases that we are going to rely on. This is the story, and this is our argument in this proceedings. Both parties file that. Then we get a court date on the opposed motion roll. Only then do we do our ex parte and our 4.2 notice again. And all of this has to be served by the sheriff. We cannot serve that in any other way. It has to be done by sheriff. And unfortunately, this is part of what increased the cost of an eviction, because we need to send the sheriff out at least twice. And we always act on urgent service, because if you send the sheriff on anything other than urgent service, you're probably only going to get your documents served in about 2 to 3 weeks. And in an opposed eviction, where we're already on 6 to 8 months, 2 to 3 weeks twice makes a massive difference. So unfortunately, this is part of why eviction costs are much higher. Once again, 14 days later, we can be in court for the hearing. It's an opposed motion, so both attorneys are there. Whether they use advocates or not is irrelevant. Both lawyers are there, and we're arguing the matter on behalf of our client because it's on application. No requirement for any other party to be in court. We don't need oral evidence. Everything is on affidavit. So it's only the attorneys arguing it out in front of the judge, and the judge then making a decision, or the magistrate, with regards to whether the parties proved their cases, so whether the applicant was able to prove ownership and illegal occupation, whether the respondent was able to say, no, I've disproved ownership. This is why I'm saying your prospects of success on an eviction, if done correctly, is really 99.7%. There's almost not a chance that you're not going to get an eviction order unless something is super funny. I've only had one eviction application dismissed ever in SSLR, but it was because our client didn't tell us the whole story, and our client was in fact not really the owner of the property. That's a whole nother story that ended in a lot of other litigation. But other than that, you will always get your eviction order if your client's the owner and the tenant is, well, the illegal occupant is in fact in illegal occupation. Just quickly, and then I promise I'll be done. I told you it's my favorite topic, so I'm taking more time than usually, but it's such a cool topic to talk about. I can't stop. The equity provisions in terms of buyers, actually things that people are quite concerned about. And I've heard people say, I don't want to place somebody in a property. I don't want to place a tenant if they fall within the equity provisions. Guys, that is illegal discrimination. We're not allowed to do that. The reason why we have these 4 equity groups, elderly people, children, disabled persons, and women-headed households, is because these are the circumstances that section 26(3) of the Constitution talks about. So the court just needs to know, is there a disabled person? So the disabled people have, I mean, there's such a wide range of disabilities, but you can't expect somebody in a wheelchair to find a wheelchair-friendly place just like this. It takes time to find a proper property to occupy, which actually caters for this person's needs. So the court will say, you're okay, you know what, you won't be able to find a place in a month, but you might need 3 months. And then the court will consider this. Disabled people, children, how far are they from their school? How long will it take to find a place that will still allow the kids to get easy access to their school? Same thing with elderly people. Women-headed households, slightly different. Remember, the Prevention of Illegal Evictions Act was promulgated prior to legalization of same-sex marriages. So when a female same-sex marriage couple doesn't receive this protection, this is where you have a single woman heading a household, which could mean that it will take longer to find alternative accommodation. I'm shaking my head at myself because as a single mom, I'm quite sure there isn't something as quick and as effective to protect her kids as a single mom, but be it as it may, I think the legislator might not have been single moms, so they might not know the power that that they actually hold. But be it as it may, there is protection for women-headed households as well. Please don't be scared if you have one of these groups in a lease premises, but this is very important. Now, thinking back of your lease agreement, the schedule that we have where we record all the occupants' details. This is the reason why we record that. So when you do a rental and you are placing somebody with a disability, just record it in your lease agreement so we can bring that to the court's attention should we need to evict that person. It's always better to take the court into your confidence, tell the court exactly what's going on, so we allow them to make an order that is in fact just and equitable, rather than trying to hide things because we are scared that that might delay the eviction process or something like that. Better to know and better to tell the court absolutely everything. Now, on that extremely high note, guys, this was so much fun. Thank you for listening to me for my little birthday month special. I hope you had as much fun as I did and have a lovely spring ahead of you.